Okay, well, welcome everyone. It's nice to see everybody on the Zoom platform, or at least you can see us. This is one of a series of webinars that the Silicon Valley Arbitration and Mediation Center is putting on. We have another one on October 8th, another one on September 16th, another one in December. So they're every few weeks. Today, we're going to be talking about the use of ADR, alternative dispute resolution, for complex business disputes, particularly in the antitrust field, which is where our two speakers, Richard Levin and I, come from. Silicon Valley Arbitration and Mediation Center, just for those of you who are not familiar with it, was formed a number of years ago as a nonprofit organization that is intended to encourage and educate about the use of arbitration and mediation in technology disputes or disputes involving technology companies. We annually publish our tech list, which is a global group of the people that we think are the most experienced neutrals, and also those who have deep experience and have been immersed in technology matters for most of their careers, either in-house or as an antitrust or a IP lawyer, someone who's got some particular expertise that they've deeply developed and who can understand the dynamics of tech industries and technologies. So I am Chris Compton. I'm president of the Silicon Valley Arbitration and Mediation Center. I grew up at Wilson Sonsini, Goodrich and Rosati in Palo Alto. My fellow panelist is Richard Levin, who is now a full-time arbitrator. He's located in Dallas, Texas. So he's not dealing with either the hurricanes or the smoky skies of Palo Alto. And Richard, like me, has had a lot of experience in antitrust matters, and we are both excited to see that enforcement agencies and private litigants and the arbitral institutions are all turning to the use of ADR tools in antitrust disputes and other trade regulation. We are going to have an opportunity at the end of this presentation for Q&A. You'll see at the bottom of your screen a little notation for Q&A or questions. Feel free to type those in and we'll get to those at the end, which should be in about 35 minutes. This is not going to be a long presentation, we hope, but we hope you'll enjoy it as much as we enjoy doing this. So with that, let me turn this over to Richard, who will start things off.
Thank you, Chris. Let's go to slide 3. So this is about antitrust is alive and well in the world of ADR, and the webinar is about, we cover 3 prongs. First is private litigation, which I'll cover, and Chris will cover government enforcement, including the new Novellus merger matter, as well as certain IP competition areas and how they intersect with arbitration and certain institutional initiatives. We go to the next slide. So in arbitration in the private area, the treble damage and injunction disputes, arbitration can come up in any competition-related claim. What you need is, obviously, as most of you know, you need a clause. You need either an arbitration clause or a submission agreement. But as far as now the type of antitrust claim, be it price fixing, monopoly claims, IP-centric claims such as fraud on the PTO, abusive manipulation of standard setting via an SEP, it doesn't matter. these all can be arbitrable as long as there's a clause or submission agreement. Same thing with consumer claims, such as the Telephone Consumer Protection Act. So let's jump to the next slide. So you got to deal with the question of arbitrability first, and that, let me take you to a little bit of history. I mean, arbitrability, as you know, is whether the claim falls within the scope of the agreement. And a word of history, the antitrust disputes were non-arbitrable until 1985. The Mitsubishi v. Solar case in the Supreme Court held that antitrust claims are arbitrable, at least in an international context, which has now been extended to all domestic cases. Mitsubishi has been followed in most foreign jurisdictions, the notable exception being China. And as we will see, Mitsubishi influences all complex arbitrations. It has a globalist perspective. The court essentially said no to a parochial concept that all disputes must be heard in U.S. courts and under U.S. law. But this was in 1985 again, and Mitsubishi looked to the needs of enforcing a party's agreement and respecting the ability of international tribunals to ensure predictability to resolve disputes, even though a contrary result could happen in a domestic court. And it's important to I'm going to keep coming back to this 1985 because it's, at that time, Mitsubishi stated that the arbitral process in international institutions were not tested, but the court was willing to take a chance, and they assumed a global perspective, a deference to party autonomy, a boost to international commerce. They stated, the court per Justice Blackmun stated that the potential was there for efficient disposition of complex disputes, the potential. And the Solar party in that case stated that these cases were simply too complex for arbitration. And the Supreme Court stated it, well, it's precisely for that reason that a streamlined, flexible, and adaptable informal process like arbitration should be encouraged. And that can result in time and cost savings and be decided by someone knowledgeable. It is essentially a trade up. And let me come to the second look doctrine, which was the Supreme Court stated that reviewing in the Mitsubishi opinion, they stated that in reviewing, the reviewing courts will see if the public policy of the competition laws was or was not addressed. Mitsubishi stated that the court review is limited. This second look is limited, it's not intrusive. And the second look is not the same as the first look of the tribunal. In fact, the very words of the court in Mitsubishi, they said that the tribunal must only take cognizance and actually decide the competition claim. So the doctrine, the second look doctrine, which is quite famous, is really pits the policy of party autonomy with the policy that arbitration cannot be used as a runaround of mandatory law like competition law. That said, keep in mind that this is, again, in the mid-'80s, and arbitration was not tested. And this fact likely spawned the origins of the doctrine to tell the stakeholders that the Mitsubishi case, we're going to find that these cases are arbitrable, but their courts will be used as a backdrop. And as it's turned out over time, that court review has been very much a minimalist review. And in any case, as most of you know, failure to apply a given country's competition law could lead to an unenforceable award under the New York Convention V2B, which states that the reviewing court will see if the award comports with a state's public policy. Let's jump to the next slide. So that said, even in antitrust cases, we still have arbitrability issues and who decides. Chris, go back one slide, please. So a hot topic is hot topic today is who decides in these antitrust arbitrations, who decides if the dispute is arbitrable. And this comes up is if a court or arbitrator, it comes up mostly in the context of where there are non-signatories or where there's a carve-out clause, which are common in IP contracts. Example being all disputes arbitrable except those concerning infringement or validity or the scope of a patent. And the Supreme Court has dealt with this issue about who decides in a couple cases. The first being the first options case in 1995, where they laid out a test that the courts are going to decide the issue unless there's a clear and unmistakable delegation in the contract for the arbitrator to decide the arbitrability issue. And there's a case now before the Supreme Court, the Shine v. Archer and White case, second time that it's come to the Supreme Court, will be decided next term. The case is an antitrust case with an arbitration clause in the distribution contract for all disputes decided by AAA arbitration, except actions for injunctive relief involving IP. And the Fifth Circuit, through Judge Higginbotham, refused to send the case to arbitration because of the carve-out clause and stated this was for the court to decide whether the claims sought to be arbitrated are inside or outside the carve-out provision. And in a sense, the Fifth Circuit conflated the who decides question with whether the dispute is in fact arbitrable. The AAA rules allow for arbitrators to decide their own jurisdiction, competence, as well as allow arbitrators to issue injunction. And the court recognized that the incorporation of the rules would otherwise be a sufficient delegation to the arbitrator. But the carve-out for injunctive relief took the matter out of the AAA rules, including the rule allowing an arbitrator to determine its own jurisdiction. So the issue up at the Supreme Court is whether that carve-out provision in an arbitration agreement, which exempts certain claims from arbitration, negates an otherwise clear and unmistakable delegation of questions of arbitrability to the arbitrator. This is how the Shine case has defined the issue, which is pretty much accurate. There's a circuit split with the Ninth Circuit and the 11th Circuit stating that the presence of a carve-out clause does not undermine the delegation to the arbitrator. The Fifth Circuit and the Second Circuit have obviously gone the other way. Let's hop to the next slide, please. So here we have a couple of practical points in the arbitration of an antitrust case. As I've indicated, Mitsubishi itself gives wide leeway in the creativity to arbitrate complex disputes and their efficient disposition. I'm lucky enough that I, as counsel, had one of the first antitrust cases to be arbitrated. And I've had several since then, and then a few as arbitrator, and I've picked up a few points that I want to pass on for what it's worth. In the area of discovery, look, generally the antitrust cases are manageable in to the extent that they are obviously derived from a contract, or they would not be in arbitration. And they're not the massive government investigations or dawn raids as you see in the EU. And even the Novelis case, which we'll cover in a minute, was an isolated issue in a merger challenge. So my best practices on documents generally is that after an exchange of documents on which the parties rely, if they want more documents, to allow document requests to be rifle shots, such as envisioned in the IBA rules on taking evidence. That is, have a category, have a why it's relevant point, and have a indicate why it's not burdensome. That said, that I should, discovery is going to be, the quantity of discovery is going to be guided by the rule of proportionality as to the complexity of the dispute. So it could be more, of course, in a more complex case. In civil law disputes, you now have, which many of these competition claims come up in civil law context, that you have the Prague rules, which are kind of the civil law counterpart to the IBA rules as far as soft law guidance on how to conduct these arbitrations. The Prague rules state that, well, there should only be specific identified documents to be exchanged, and the tribunal is in fact cautioned to avoid extensive document production. Generally, depositions, you see that a lot in the US. I mean, it's depositions really work best if the witness cannot testify at the hearing. I mean, if the case is very complex and is, many times you see the rules, very good rules like the AAA procedures for large, complex disputes, they strike a good balance, allowing limited depositions upon good cause shown. Where Mitsubishi, I believe, makes its biggest mark is in the area of experts. Mitsubishi itself referred to expertise, both arbitrator expertise and opinion testimony, as the hallmarks of arbitration. And you're going to have, in these competition disputes, they're going to be very much grounded in economic testimony. It's issues such as relevant market definitions, barriers to entry, why certain companies are good entrants, other countries are not, the timing of entry, the cost of entry, issues such as supra-competitive pricing like the Shine case, fair non-discriminatory licensing practices. Is there more or less competition over time? These are all questions that are best heard out of the mouth of an economist. And where Mitsubishi's penumbra kicks in, I feel, is that the traditional adversarial methods to elicit expert testimony in court, that is by cross-examination by counsel alone, is not as robust and indeed wastes flexible tools that an arbitrator has, such as witness conferencing and questioning with experts simultaneously, hot tubbing of experts via the IBA rules on meet and confer, teaching sessions on technical and background points. And I believe technical experts, the SVAMC is having a webinar in a couple weeks on technical experts. And I ask you all to attend on that. The IBA rules 5 and 6 strike a good balance, allowing structured counsel and tribunal questioning. And the arbitration process is best, I have found, over years as counsel and as arbitrator, and in court and in arbitration. I have found that the arbitration process allows you to get to the truth faster and cheaper, cut to the chase with less histrionics. My late colleague, Johnny Veeder, he had a phrase that he called this procedural and evidential flexibility, where the cross-examination of experts by counsel alone is just not productive. And back on civil law and experts, depending on the law governing the composition of the tribunal, the seat, counsel involved, the civil law approach to experts is radically different than the common law approach. Civil law experts owe their allegiance to the process and the tribunal and not to the parties. And generally, counsel cannot confer with experts prior to the hearing. And the Prague rules deal with that as well. I should say the IBA rules have some civil law impetus as well in there. And they actually require a statement of independence by a party appointed expert to that party. So generally on experts, I have found that arbitration provides a more robust process of eliciting expert economic testimony, and that complex testimony does not really, especially by economists, complex testimony by counsel alone is not the best way. Arbitration allows these flexible ways of tackling these complex issues faster and less expensive. And again, I go back to Mitsubishi, as that was recognized by that court as to why these cases are arbitrable. Finally, let me just touch on summary adjudication, because we're seeing more and more institutional rules providing for dispositive motions for the right case. You see that now in Singapore, in Sweden, in London, in the new London rules, and the ICC by practice note in the AAA. And summary rulings, especially, they join the policies of arbitration, of expedition and less expense. Now with this substantive trend in antitrust cases as seen by cases such as Matsushita and the Supreme Court handed down around the same time as Mitsubishi, and well as Twombly, another Supreme Court case requiring, in these cases, require a plausible basis to state if you're going to assert an antitrust claim based on concerted activity through circumstantial evidence, especially a plausible basis, especially if there's a competing benign inference. But I'm really talking about summary rulings, and I think the way I feel is summary rulings very much relate to defenses as well as claims, and they are strikingly benign in arbitration as they're consistent with these policies of expedition, and at the same time they don't take matters away from a jury, which is why you don't see too many summary rulings in court. Most common, I believe, simply dealing with summary rulings on partial issues in arbitration and streamline a case, which could help significantly expedite and reduce the costs of arbitration. All this said, it's extremely important to keep in mind that the case, as in court litigation, the case must be the correct one for a dispositive motion. And there I refer you to the New York Convention V1B and the vacator rules under the FAA about procedural fairness, such as a refusal to hear material evidence and the right to be heard. Thank you all, and I'll turn it back to Chris.
Okay, thank you, Richard. Mitsubishi is a good bookend in 1985, as discussed by Richard, for the Novellus case earlier this year, just before we all started sheltering in place, because this was the first occasion in which the government, the DOJ in this case, actually submitted a key issue in a merger challenge to arbitration. The government has had the authority to do this under the Administrative Dispute Resolution Act of 1996, but that had never been exercised before. And really for the reasons that were articulated in the 1985 Mitsubishi case, the DOJ came to decide that it was worth trying arbitration on a key issue in a merger challenge. This is a $2.6 billion merger between a couple of suppliers of aluminum used in auto manufacturing. And the key issue in that case was market definition, as it often is in antitrust cases, whether or not steel used in auto manufacturing was a competitive, part of the competitive relevant market or not. If it were, then the market was not that severely impacted by the merger, and presumptively it could go forward. But if aluminum used in auto manufacturing was the relevant market, excluding steel or other metals, then there would be a significant impact on competition and the merger would be in trouble. So what the DOJ decided to do, in agreement with the parties, and they all had to agree to this, was to submit that market definition issue, just that issue, to an arbitrator. And here's the other tie-in with Mitsubishi. They chose an arbitrator who was an antitrust lawyer and had a lot of experience in the antitrust world. Remember, Richard talked about Mitsubishi's emphasis on arbitral as well as expertise in these proceedings. And so the DOJ and the parties were satisfied that the arbitrator that they chose in this case had sufficient experience, knowledge, understanding of issues like market definition to be able to make this decision. So they submitted it to this arbitrator. And after a relatively short period of time, in other words, measured in weeks and months rather than years, the arbitrator came back earlier this year and decided in favor of the DOJ. In other words, that the market was the more narrow one, consisting only of those who used or provided aluminum for the customers that manufactured automobiles. Now, this was a big breakthrough, and the question really was, how did it go, right? Everybody wanted to know, and we still want to know, is this going to happen again? Was it a successful experiment? Because that's really what it was as a first-time occasion. The Assistant Attorney General for Antitrust had a press release and answered questions as well about this decision, called it an effective procedure for streamlined adjudication of a dispositive issue that saves significant time and money for all concerned. You know, look back, for those of you who have done merger challenge litigation or investigations by the agencies, the DOJ case against Oracle is one of the tough examples. That went on for more than 2 years from start to finish. When Oracle was trying to acquire PeopleSoft, it went through a full trial in the Northern District of California before Judge Walker. You can be sure that tens of millions of dollars in fees and costs were incurred with economists and the lawyers, all the lawyers on both sides. It still wasn't a huge amount relative to the size of the deal, but by comparison, had that or any key part of that, such as the market definition, which was a key issue, Had that been decided by an arbitrator, you can be sure that would have been done much more quickly and at much less expense for the parties. So in sum, the Assistant Attorney General for Antitrust signaled that it was likely that the DOJ at least would use arbitration again where it was appropriate. The key determinants being, can you actually get the DOJ or perhaps even the FTC in agreement with both parties on a set of procedures and rules, essentially an arbitration agreement, a submission agreement that would be acceptable to all of them. In this case, the terms of reference, more than simply setting out what the issue would be, the relevant market issue, went on to say how much discovery would be permitted, would there be third-party witnesses, how much time would the arbitrator have to make his decision or her decision, and most importantly, what was to happen depending on who won that case. So it was spelled out in the agreement, submitting this to the arbitrator, that if the DOJ won, certain divestitures would have to be made by the parties in order for them to go forward with their merger. And that is exactly what happened. The key question then is always going to be, who is going to be the arbitrator? And that ties back to SVAMC, because the whole purpose of our organization is to publish annually, or at least a big purpose is to annually publish a list we call the tech list, which are a group of people who have deep experience in both ADR, but also in relevant technologies and the technology industries. So that's the kind of source. In our case, it's about 54 people at this point. It expands or changes each year. That's the kind of source that the government or private parties can look to as saying, all right, here's somebody who has experience. Here's somebody we can rely on to deal with this issue without submitting it to a jury, for goodness sakes, or even a judge that may not be experienced in the IP or in the software market or in the molecular biological market or other technology-oriented issue that is the question. Now let me turn quickly to another big area of exploding use of arbitration. And many of you will be familiar with these. We call them the FRAND cases. This stands for fair, reasonable, and non-discriminatory. That is a standard that standard essential patents have to abide by. So standard setting organizations, of which there are hundreds globally, they can range from everything from the standards set for light bulbs to electrical outlets to semiconductor packaging to networking, all the things that help commercialize technologies in a way which enables consumers or the purchasers of those products to get a wide variety of sources and know that they're all going to meet whatever the technical standards are that are set. When those standards are set by a body, by a standard setting body, there's typically a requirement that all participants in this body have to agree that they will license whatever technology they have, patents typically, but it may be beyond that, that they will freely license those technologies to anyone exercising the standard. And they have to freely license those on FRAND terms. Fair, reasonable, and non-discriminatory terms. This has given rise to hundreds of cases where parties are litigating against each other to question whether or not a particular license that's being offered meets the FRAND requirement. The government got involved in this back in 2008 in the Data case, where the FTC went after Data, which is a very small company, alleging that it was violating Section 5 of the FTC Act, committing an antitrust violation by its licensing terms because they were, according to the FTC, not FRAND-based in some respect. There was a lot of controversy about that case, but nevertheless, it established the precedent, if you will, that antitrust has a role to play in determining whether a company is complying with FRAND in its licensing policies. There have been a whole raft of cases that I'm sure many of you read about against Qualcomm. Apple's been involved, Broadcom's been involved, and many others as well, alleging that Qualcomm's licensing policies were not just contractual violations of their commitment to the standard setting body by not being FRAND compliant, but rose to the level of antitrust violations, that they were intended to or did have the impact on competition that foreclosed competition, harmed competition in a way the antitrust laws were designed to prevent. Now, just in the last few weeks, the FTC has reversed, the Ninth Circuit has reversed an FTC win in the district court against Qualcomm. And Qualcomm's business model is now essentially vindicated in the Ninth Circuit, because the Ninth Circuit has ruled essentially that this is a contract matter, that there is not sufficient showing in that case of an impact upon competition to make this an antitrust case, that the remedy against an SEP holder, a patent holder, is contractual for breach of its commitment to the standard setting body, not an antitrust issue. And I've given you a site there that you can look that up in more detail. That's not to say there can never be an antitrust violation, but the Ninth Circuit decision constrains that model, if you will, in favor of a contractual remedy, which is what the debate in the antitrust community has been about for some years now. Meanwhile, because there have been so many of these FRAND cases, I wouldn't say every time there's a dispute about a license, but certainly many times there's any kind of licensing dispute, you're going to have a claim by the party that's trying to get access to the technology that the licensor has failed to comply with FRAND on standard essential patents. Because there have been so many, the various agencies, WIPO, World Intellectual Property Organization, has a whole set of rules for how FRAND cases should be arbitrated. And has really, its premise is that IP arbitrators may be better able to set FRAND rates than judges or juries, if indeed setting of those rates is what the litigating agency or arbitrator needs to do. The TCL versus Erickson case, along with the Snyder case, the case that Richard mentioned earlier, is also before the Supreme Court now. Well, see, there's a petition for cert before the Supreme Court. The court has not accepted it yet, but it raises this issue squarely as to who decides the FRAND rate. Should it be a court or a jury? If it's a court, then that should certainly encourage the reference of these kinds of determinations to arbitrators. Because if you're not going to have a jury determining this, you might as well think seriously about having an experienced arbitrator who has done these FRAND cases, who understands what FRAND is, who understands what patents are, who understands licensing and the world of licensing. So there are a lot of amici have weighed in on this. We will find out whether the Supreme Court accepts cert in that case. And if they do, we'll have an important decision coming down over the next term. Meanwhile, again, a few weeks ago, on July 15th, a German High Court decision came out that very much favored SEP holders, the patent holders, the licensors, to the extent that commentators feel there may be a rush to enforce patents and to limit licenses or limit the terms under which the patent holder has to license in the German courts. That gave very broad license, if you'll excuse the pun, to the patent holder to be compliant with FRAND in even putting out different license royalty rates to different licensees, and even putting together bundles of patents that differ and require the license of an entire bundle rather than an a la carte menu, which many licensees feel that they want. So the German court is very SEP oriented on these licensing issues under FRAND. We have the Supreme Court in the US coming down, we hope, with some decisions on this, if they accept cert, on who decides that issue. And you have the Ninth Circuit weighing in that, again, the SEP holder has rather broad field in which to play and still be compliant with its FRAND obligations. Along with the WIPO rules for arbitrating FRAND cases, the AAA has also emphasized its own focus on the arbitration of technology disputes, including FRAND, but the whole range of technology disputes. And you'll see on its website, they spend a great deal of time and have a number of resources set forth, and a panel that has a lot of experience. Some parts of that panel have a lot of experience in this area too. They point out in 2019 that there were 405 technology cases submitted for arbitration by the AAA or the ICDR. Many of them software systems development. I just finished a case involving implementation of a major software project. Partnerships and joint ventures, licensing issues. Many of these cases can go to mediation and be resolved quickly. To the extent they can't, if the parties wish to submit them to arbitration, even if there is no clause requiring that, they're free to do that, and the AAA is seeing a lot of these cases coming up. So we're encouraged at the SVAMC that tech companies are starting to use and look to arbitration. And I think the Novellus case by the government is a major endorsement of ADR in technology cases. If the government's willing to turn over the key issue to an arbitrator, query why private parties, as discussed by Mitsubishi, should not be also seriously considering. So let's resume, let's do a quick resume of the benefits for arbitration. You've all been familiar with these. I mean, it's speed of resolution, it's cost savings, it's confidentiality. Arbitration proceedings are confidential. No press releases, no reporters in the courtroom, a little bit more freedom of the parties to put on the evidence that they think is necessary without worrying whether it's going to be disclosed or manipulated in the press. Ease of enforcement is a big issue, particularly in international arbitrations, because most countries have treaties, arbitration treaties, that under which an arbitration award in one country will be enforceable by the courts in another country. So you don't have to worry about taking a decision out of the Northern District of California and going to Japan and seeing if you can get that enforced there, which can be very problematic and time consuming as well. And finally, you do have increasingly at the AAA, in WIPO, in various arbitral institutions and the SVAMC, groups of arbitrators who have enormous amount of experience in technology industries available to you. Okay, so now I'm going to give anybody an opportunity to ask questions. We'll see whether or not we have any lined up at this point. You see on your the bottom of your screen, there is a place for Q&A. So take a moment if you wish to put something in there. Before we start that, let me ask something that's often been asked of us, and it goes to some of what Richard and I have been talking about. Why is it the tech companies have been so slow to use arbitration and mediation? That is really the question we asked at SVAMC 5 or 6 years ago when we started this organization, because all of us grew up in the tech business one way or another. And we saw as litigators how seldom arbitration clauses were in these license agreements, these joint ventures, these collaborations, these R&D collaborations, these contracts to implement a software enterprise system, whatever it might be. Why was there so little use of arbitration? And we've been spending a lot of time surveying and talking about that issue. Some of it is just lack of understanding of what's available. Some of it was worry about what will happen in front of an arbitrator because the appellate courts aren't there to step in and have a de novo review. And do we really want to put our decision in the hands of an arbitrator? Well, if you're going to put it in the hands of a court, I'm not sure why the hands of an arbitrator would differ, but that was an issue. But the main one was the one I mentioned earlier, which is the lack of a clear, or the absence of a clear group of experienced neutrals who had technology experience, deep technology experience. And that's why we publish our tech list. So I'm encouraged now to see that a lot of companies in the tech business here in the Silicon Valley and the other tech centers like Dallas, Houston, I mean, not Houston's, well, Houston in the oil business, certainly. Austin, computers, semiconductors, Boston, Route 128, Seattle, the Research Triangle, and in other, foreign jurisdictions. Various tech centers are appearing more and more important parts of the economy. Those companies are increasingly starting to pay attention to the possibility of ADR. And we find that tremendously helpful and encouraging because, particularly with technology industries, those are the ones least able to afford a 2-year, a 1-year burden on their time and their fortune to come to a decision about an important business issue. Tech works too fast. Tech goes too fast. It's obsolete in 2 or 3 years, 4 years, less than that sometimes. So it's a mystery why tech companies would ever fail to consider mediation and arbitration. And that mystery is starting to be dissipated, I think, as we go forward.
Chris, I think we have a question from Paku.
Okay, go ahead and cover that one, Richard.
Well, I'll try, Paku, but I thank you for the question. I think, in my opinion, again, for what that's worth, I don't see any impediment to any type of issue in an ordinary antitrust dispute that I have seen that would not be suitable for arbitration. I know that in the Novellus case, that was a peculiar case that they cut out a defined relevant market issue to be defined, but you could have there's no reason why you can't have a case soup to nuts being completely arbitrated. I don't see any type of particular opinion. I mean, I think obviously if something gets into the criminal area, that is generally, or that is completely non-arbitrable. But in some competition statutes are criminal as well. So, but otherwise, there's nothing I would think that's not perfectly suitable to arbitration. Thanks for the question.
Yeah, the question, just to repeat it if anybody didn't see it, is are there any issues in our antitrust that Richard did not think were suitable for arbitration? I've heard the opposite question, which issues besides market definition might be in a very limited way submitted to arbitration? And I can think of a number. You might have ease of entry determined by an arbitrator. You know, who are the competitors that will step in within the 1 or 2 year periods set out in the guidelines, should there be an impact on competition or an increase in pricing by the merging parties. That's an issue that is very factual. It could be determined by an arbitrator who's experienced with working with the guidelines and with the cases. Another one might be the efficiencies defense. Another one might be the failing firm defense. Mind you, I've never seen a failing firm defense that worked, but you could ostensibly refer that to arbitration. But I agree with Richard. There's no inherent reason why you couldn't submit an entire antitrust case, claims and counterclaims, to arbitration if you have an arbitrator who's experienced in that area. Okay, let's see. I think we have pretty much run out of time. The slides will be available for anybody that would like to get these. You can contact either Richard or me and we'll send them on if they're not automatically sent to you. Actually, I think they'll be automatically sent since we have your emails. Meanwhile, Richard, thanks for participating. This was fun, and we appreciate the attendance by the participants. We hope you got something out of this, and we look forward to talking to you again. Take care.